how citizens' rights can be protected against national or state government. So this is in your PowerPoint. If you turn to this page, we will go over this section dealing with many of the amendments. This chart basically goes over the Due Process Clause. Remember, the 5th and the 14th Amendment both contain due process clauses. And so I just want to explain that principle a little bit more. The 5th Amendment provides that the federal government cannot deprive any person of life, liberty, or process without due process of law, meaning that we are guaranteed procedural things by the government, either national or state, in how they act and what types of laws they act under. The 14th Amendment also says that state governments, this is federal or national, that state governments cannot deprive any person of life, liberty, and property without due process. So this is the guarantee of the Due Process Clause. I want to look at the portion that deals with really the interpretation of due process. It's either procedural, meaning how does the government carry out the laws? Did they search appropriately? Did they issue a warrant appropriately based on probable cause? Did they pull over people correctly? So this is the how of the government acting. If it's substantive due process, it means the what, or what is it that the government is upholding? So this would be, is the law valid? Is the court order valid? What is it that the police are doing? Because sometimes under procedural, state or national power may act incorrectly, but under substantive, they may be doing everything correctly, but the law is faulty. So really, the Supreme Court has delved into these two meanings, and that's what they've come to mean under procedural and substantive due process. The 5th Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. The 14th extends that restriction to state and local governments. Remember, due process says that the government must act fairly and in accordance with established rules at all times. Due process is broken down into two main things: substantive, which is the fairness of the law itself, and procedural, the fairness of the procedures used to enforce the laws. So as I go through these next several slides, think to yourself, was it how the police or how the state acted, or was the law itself faulty in what they were carrying out? This again breaks it down. Government in all that it does must use fair procedures, the how. So how the police investigated the crime scene, how the house was searched, how the police arrested a criminal or person under suspected wrongdoing. Substantive examples. The government acts, and the laws under which it acts must be fair. So for example, what law was unconstitutional? Was the law unconstitutional? Was the law violated? Did it violate a set of people, a minority group? So these are really big questions in dealing with police power and how the police have to act. Remember, it is the power of each state to uphold public safety, and that means promoting health of the citizens, promoting safety, promoting morals, and promoting the general welfare, which is in the preamble. This is an example under the 3rd and 4th Amendments about protecting the security of the home and person against the government. The 4th Amendment protects us against writs of assistance, and that would mean a blanket search warrant. The police know they want something, but they're not sure what. Writs of assistance are not allowed, and it's called an unreasonable search and seizure. That was extended to the states through the 14th Amendment in the case Matt versus Ohio. And I've given you these handouts, or you can look on the website for them. Wolf versus Colorado originally did not extend the case. This is the precursor to MAP. It did not extend those protections to the states. But the court case Matt versus Ohio, when you see this case, you should think exclusionary rule. Evidence gathered in violation of the Constitution cannot be used in trials. This is referred to as the exclusionary rule. In MAP versus Ohio, the exclusionary rule applies to the states as well as the national government. Now, there are rules to the exception. There's what we call the good faith rule, that sometimes something is taken unreasonably, but the police thought they were doing it in good faith. They might have had the wrong address, or there was human error in writing down something, and sometimes the court will give a good faith exception to that. These are areas that are considered search and seizure areas. Does the police have probable cause? How can you search an automobile? What about wiretapping or taping people's phone conversations or using that evidence without the other person knowing? Is that legal or not? What defines illegal search and seizure? How is a person arrested? Were they read their rights? Do they know their rights? Can evidence be submitted if it was taken illegally? What about drug testing? Is it allowed during the school day? Is it not? Do you need parent permission? Is searching a person's body by withdrawing blood or a urine sample or any of those things against what the government would, or what a person would consider reasonable search and seizure or unreasonable search and seizure? So those are some of the questions that the court has to deal with. In the Fifth Amendment, it declares that no person can be compelled in any criminal case to be a witness against himself. We call that pleading the fifth or self-incrimination. This protection does extend to state courts as well, and sometimes to civil trials if self-incrimination could lead to a criminal charge. People can plead the fifth. A person cannot be forced to confess to a crime under extreme circumstances. A husband or wife cannot be forced to testify against their spouse, although they can testify voluntarily. The court case MAP versus Ohio. When the police were looking for someone, they went to the home of Dolly Mapp or Dalry Mapp. Police did not find the suspect, but they arrested her for possessing obscene materials in the basement in a trunk. Without a warrant to search for the literature, Miss Mapp's conviction was thrown out. Remember, they were looking for a person, and they found this illegal literature or pornography in a trunk of a former tenant. So that sort of set the precedent for search and seizure. Another court case that deals with criminal rights is called Escobedo versus Illinois. Now, Escobedo and Miranda are very important rights of the accused that have been landmark cases. Escobedo was ruled in 1964. After confessing to a murder during questioning, Danny Escobedo changed his mind and informed police that he wanted to talk to a lawyer. When police documents were produced showing that officers had been trained to ignore the rights of suspects during questioning, the Supreme Court ruled that Escobedo's self-confession could not be used as evidence. So sometimes these decisions do help the accused, but it also safeguards that the police are following the rules. The next big court case is called Miranda versus Arizona, and you can see these were all ruled. Mapp and Escobedo and Miranda were all ruled within about 5 or 6 years of each other. This was a very activist court in defining police power and what was allowed. So we can go over those sections so that you can see the full law, but the 60s were very active in this. In Miranda versus Arizona, the Supreme Court set a historic precedent when it would no longer uphold convictions in cases in which the defendant had not been informed of his or her rights before questioning. This requirement is now known as the Miranda Rule, and I've given you this court case in a little bit more detail. The Miranda Rule, or the Miranda right, states, a person has a right to remain silent. Anything a suspect says may be used against him in a court of law. A person has the right to have a lawyer present during questioning. A person has the right to have a court-appointed attorney if the person cannot afford one. A person has the right to end questioning at any time. And I said this again just a minute ago, but the Supreme Court under Chief Justice Earl Warren really expanded the rights of the accused. The Rehnquist Court validated the Miranda case about 10 years ago or so, and the Miranda ruling came up again, and it was questioned, do we really need to do this? And the court reaffirmed that the Miranda rights should be read. In the Fifth Amendment, some of the rights of the accused are listed here again. So I think those are self-evident as you read through those to look at the rights of the accused. The Sixth Amendment is designed to protect individuals accused of crimes, and this includes the right to counsel, which is the right to have an attorney, the right to confront witnesses who are saying things against you, the right to a speedy and public trial. One major court case dealing with the Sixth Amendment is the case Gideon versus Wainwright. Again, during the Warren Court era, this was a handwritten petition. Gideon wrote this to the Supreme Court in the form of a papyrus, which is right down here, basically saying, I am too poor to defend myself, and I'm going to handwrite this note on behalf of my cause, and I'm petitioning to the U.S. Supreme Court. So going back up here, the Supreme Court held that anyone accused of a felony where imprisonment must be imposed, however poor he or she may be, has a right to a lawyer. This was in a state case, and this is the case that nationalized the Sixth Amendment to apply against state courts as well. So Gideon had been convicted of robbery, was sentenced to 5 years in prison. Too poor to defend himself, he filed a handwritten in form of papyrus petition to the Supreme Court. The Supreme Court not only accepted the case, it overturned his conviction and granted a new trial, and he was acquitted during that trial. And this is a sample of his handwritten note. Remember, trial by jury is guaranteed in the Sixth Amendment as well. You're guaranteed an impartial jury chosen from the district where the crime was committed. If the defendant waives the right to a jury trial, you can have what is called a bench trial, where the judge sits alone to hear the case. I do want to talk about this last one. We mentioned this at the beginning of the year under the Patriot Act. And after 9/11, the FBI detained more than 1,200 people. And I can't emphasize this enough, and I explained it earlier in some Freedom ones, but there's a difference in wartime and peacetime. And President Bush declared a war on terror. And under this, 1,200 people were seen as dangers to national security. 762 were illegal aliens. The government withheld their names and reduced their right for access to the court system and to counsel. And some people thought that this violated the Fifth and Sixth Amendment. When the Patriot Act was passed, increasing federal powers and investigations, it said terrorists it said the federal government could tap any telephone used by a suspect after a court order was given. The Patriot Act authorized tapping of internet connections with a court order. The Patriot Act said you could seize voicemails with a court order, that you could share information learned in a grand jury. Any non-citizen could be held as a security risk for 7 days or longer. It said that you could track money across U.S. borders to other banks. It said a statute of limitations, I think I spelled that wrong, on terrorist crimes was eliminated. So if you didn't do it in 2 years, then that person could go free, and that eliminated the statute of limitations. There is a famous court case called Hamdi versus Rumsfeld. Rumsfeld was the current Secretary of Defense, so therefore was named in the case. And in this, Hamdi was one of these people who had been arrested. The Supreme Court found that detainees in Guantanamo Bay or held in these prisons, held in the U.S. or in Guantanamo Bay, have the right to challenge their detention before a judge or other neutral party. And so what this is saying is before they could be held indefinitely, and they didn't know what they were being charged with, nor did they know if they would ever have a court trial. And the Supreme Court said regardless if you're citizen of the United States or not, that you have the right to be heard before a judge. This portion just basically goes over that people have the right to a speedy and public trial, and normally speedy means within 100 days after the arrest. Also, in dealing with the Eighth Amendment, setting bail, the bail cannot be excessive. And preventive detention is a law that allows federal judges to order accused felons be held without bail if there is a danger that the person will commit another crime or flee. That's normally the case, and you can look at those issues there. Two large court cases that deal with this, the Eighth Amendment, is also about cruel and unusual punishment. And so I just put several examples there about cruel punishment, but I wanted to look at this one. Generally, the court has not found many punishments to be cruel and unusual. There is the issue, though, of capital punishment, which is otherwise known as the death penalty. And for a while, the Supreme Court outlawed or voided capital punishment and said you can't have it because it's only really given to a few people, and it's a high rate of African Americans or the poor. And so they thought we need to put a moratorium on the death penalty and outlaw that for a while in the 70s. But in 1976, the court held for the first time that a new law which instituted the death penalty was not unconstitutional. The new law provided for a two-stage trial process, and so the death penalty was reinstituted. But there is still a lot of debate around this issue. Two large cases that deal with the death penalty are Furman versus Georgia and Gregg versus Georgia, both in the 1970s. Is the death penalty cruel and unusual punishment? And that is when the court overturned Georgia's death penalty law because they said more clarity was needed. But in Gregg versus Georgia, the Supreme Court upheld the constitutionality, and you can read through that, and they said that the death penalty is not cruel and unusual punishment. The last part that I want to look at is the Ninth Amendment. This is unenumerated rights, and the Supreme Court has said that there is a degree of privacy which they have ruled under the Ninth Amendment. I've talked in class before about Griswold versus Connecticut, which held that the Connecticut law outlawing birth control was unconstitutional due to privacy. Stanley versus Georgia, the right of privacy was defined as the right to be free, except in very limited circumstances, from unwanted governmental intrusion into one's privacy. One of the largest cases that have dealt with the right to privacy for people's bodies is the court case Roe v. Wade in 1973, a landmark case which considered women's rights in having an abortion. And I'm not going to go through all of these. I feel these are self-explanatory once you read them. But through the years, Roe has been clarified. The state ban on all abortions were unconstitutional, except in these, and they went ahead and did the first, second, and third trimester about how states can regulate abortions and the use of abortions. Webster further clarified it, and Planned Parenthood versus Casey upheld other things like waiting periods and parental consent. This Sternberg versus Carhart was a newer one on partial birth abortions, and you can read that as well. So that's it on the first portion of civil liberties and civil rights. Under criminal prosecution, dealing with most of the amendments going up to number 9, you can watch the other portions on freedom of religion and civil rights.